Ladies and gentlemen of the jury, you have heard the evidence presented by the parties and the arguments of the attorneys, and you are now to hear from the court the rules of law which lie at the foundation of the various contentions of the parties. The rules which, when applied to the facts which you find, will lead to your ultimate verdict. You, ladies and gentlemen, are the sole judges of the facts. You are to find the facts, and in so doing to recollect the testimony, and from that recollection of the testimony, including the weighing of that testimony and passing upon the credibility of witnesses, draw your own conclusions as to what the ultimate facts of the case are. You are allowed to draw natural and logical inferences from facts you find proved, but you may not go outside of the evidence admitted during the trial of this case to find facts, nor may you resort to guesswork or conjecture. It may be from time to time in the course of the charge that I will refer to some of the evidence in the case, and if I do, and your recollection of the evidence is different in any way from what I have stated, and in fact, if your recollection of the evidence is different from that stated to you by either of the attorneys in their argument, it is your recollection that must govern, because, as I said before, you and you alone are the judges of the facts. The law, of course, you take from the courts, and that without regard to any claims which have been made by counsel during the trial or during argument, and without regard also to any convictions you may have yourself as to what the law is or what you think the law ought to be as applying to the kind of case that has been presented before you here. There are, generally speaking, two types of evidence from which a jury may properly find the truth as to the facts of the case. One is direct evidence, such as the testimony of an eyewitness. The other is indirect or circumstantial evidence, that is, inferences which may be drawn with reasonable certainty from proven facts. As a general rule, the law makes no distinction between direct and circumstantial evidence, but simply requires that the jury find the facts in accordance with the preponderance of all the evidence in the case, both direct and circumstantial. Thus, both direct and circumstantial evidence is permissible. Each type should be treated equally. In your consideration of the evidence, you are not limited to the bald statements of the witnesses. On the contrary, you are permitted to draw from facts which you find have been proven such reasonable inferences as seem justified in the light of your own experience. You as jurors are the sole judges of the credibility of the witnesses who appeared before you and the weight their testimony deserves. No fact is, of course, to be determined merely by the number of witnesses testifying for or against it. It is the quality, not the quantity, of the testimony which controls. In weighing the testimony, you may use the tests you would ordinarily use in determining the truth of matters important to you in your everyday life. Ordinarily, it is assumed that a witness will speak the truth, but this assumption may be dispelled by the appearance and conduct of the witness, or by the manner in which the witness testifies, or by the character of the testimony given, or by evidence to the contrary of the testimony given. You should carefully scrutinize all the testimony given, the circumstances under which each witness has testified, and every matter in evidence which tends to indicate whether a witness is worthy of belief. Consider the intelligence, motive, and state of mind, the demeanor and manner of each witness while on the stand. Consider also any relation to the witness may bear to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, the witness is either supported or contradicted by other evidence in the case. You are at liberty to choose what testimony you will believe and to discard in whole or in part the testimony of any witness. In weighing the credibility of the doctors and economists who testified in this case, you should apply the same standards to which any other witness is subjected. Ordinarily, the rules of evidence do not permit witnesses to testify as to opinions or conclusions. An exception is made with respect to expert witnesses. This type of witness may state an opinion on relevant questions in his field of expertise. You should consider such expert opinion received in evidence in this case and give it such weight as you may think it deserves. Among other things, you may consider the actual skill possessed by the expert, the experience he has had, and the training he has had. If you should decide that the opinion of an expert is based on reasons which are not sound and rational, you may reject the opinion entirely. On the other hand, if you find the basis of the opinion is sound and rational, you may accept it entirely.